Doctor, do you agree that this textbook is authoritative? No, I don't. Doctor, this is a textbook that is sitting in your office on your shelf, isn't that true? Yes. And this is something that you refer residents and other doctors to if they have questions about your particular specialty. Isn't that true? Yes. And isn't it true, doctor, that you will on occasion refer to this particular textbook to get information and answers to your particular questions? Yes, it is. And doctor, isn't it true that there are certain passages in here that you consider to be authoritative? Yes, it is. Your Honor, at this time I offer this textbook into evidence. Defense counsel, what do you have to say? The judge asks. Your Honor, I object. This textbook is not authoritative. The doctor just said it's not authoritative, and therefore he cannot admit the entire textbook into evidence. Objection sustained, the judge says, which means I can't get that textbook into evidence. Doctor, will you agree that there are certain passages in this textbook to which you consider to be authoritative? Yes. Okay, doctor, let's take a look at certain of those passages. I'm going to read to you from page 171, which says, and now I'm going to read him a phrase from that particular textbook. Doctor, do you agree that that phrase is significant? Yes, I do. Do you agree that it applies to this particular case? Yes, I do. When taken in context, what this phrase talks about, would you agree that that is authoritative? No, I don't. Doctor, are you saying that you have more experience than this particular author? No, I'm not. So now the doctor's fighting with me, and there's a key reason why he's not acknowledging the fact that this page or this portion of the page is authoritative. You want to know why not? The moment that the doctor acknowledges and admits that something is authoritative, I can now use that to contradict something he's said. I can use that to contradict something he's testified about. And clearly the doctor doesn't want to get into that fight. Because if he did, what would happen is, doctor, the author of this textbook has been in practice for 30 years, and this is their specialty. Are you telling this jury that you have more experience and more knowledge than this author? No, I'm not. What I don't want to do is ask the doctor, tell us why this passage you believe is not authoritative. That's something I don't want to do. I don't want to give him the opportunity to explain anything. Instead, I want to try and lock him into his answers and show that there's a clear body of evidence, medical literature, that contradicts his position, that contradicts his testimony. And the moment he opens that door by saying, yes, this is authoritative, that's it. Now I'm going to use that as evidence in chief to show and contradict what he's testifying about. So why do I share this great information with you? I share it with you to give you an insight and an understanding to what goes on during cross-examination when a medical expert takes the stand, and now I'm trying to use a textbook to cross-examine him about the information contained in that particular textbook. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.